Hi, everyone. My name is Susan Lawson. I'm one of the partners here at the Rossen Law Firm and also a board-certified criminal trial attorney. And today we're going to, in my portion, we're going to talk about how to issue spot and work a DUI case pre-trial, as well as discuss a very, maybe dry, but very important issue of DUI motions. So when you get the discovery for a DUI case, it's very important to review and gather all the important information. And this is by no means an exhaustive list, but some things, and I'm going to go through some things that I didn't even include on here. So the first thing you should look at is the probable cause affidavit. In every county, it's called different things. For example, in Miami-Dade County, it's called the A form, but really the police report and the narrative police reports that show and explain what the police officer wrote down, that their observations that happen. Now, when you're reviewing the probable cause affidavit and the narrative, there may be some police officers that are listed in the narrative or the probable cause affidavit that are not on the witness list. And it's important to take note of who these officers are, because by being listed in discovery, even if they're not on the witness list, you're deemed to be a notice about these witnesses. So you can't later claim a Richardson violation or that you did not know about these witnesses. And this happens all the time. So it's important to notate all the details in the probable cause and narrative and read it very carefully. A lot of times I'll even do an outline, outlining the issues I see, if there's different officers, what role each officer played when going through the probable cause affidavit and the narrative. So in addition to, when we say narrative, that's basically supplemental reports. So some officers do narratives and supplemental reports, others don't, but it's important to figure out what everyone's role was and who did what. Something else that's very important, especially in DUI cases, are the tickets. So obviously you have the DUI ticket, which initially the DUI ticket for the first 10 days until someone decides if they want to elect to have a formal review hearing with the DMV or waive a formal review hearing. That ticket is their driver's license. But it's really important, there's going to be a DUI ticket, but to look for the other tickets. To see what traffic, if any, what traffic citation tickets someone was issued, right? Because that tells a lot about the stop. So if officers alleging they stopped your client for speeding, did they write a speeding citation? So it's very important to get those tickets as a part of when you're reviewing and gathering discovery. Something else that's very important. And a lot of times the state provides it. They don't always provide it. So if not, you could always try to get it on your own. But you want to know your DMV driving record, right? So Manny is going to talk about initially gathering the information from your client. But sometimes clients don't know, this might not be their first DUI. And they might not know when their first DUI happened. So by getting someone's DMV driving record, we can gather that information because it's very important to know that information. If this is someone's second DUI and it's inside 5 years, so meaning this is the second one within 5 years, there's a mandatory 10 days in jail. So it's very important to know if this is a second within 5 or a second outside of 5. Additionally, if this is someone's third DUI within 10 years, a lot of times the state files that as a felony, whereas opposed if it's outside 10 years, that's a misdemeanor. So these are all really important things that you need to know in the discovery process. So getting your client's DMV driving record is really important. So, and something that's really important that isn't on this list, and again, previously said, by no means is this list exhaustive, but body-worn cameras. So most police agencies now have body-worn cameras. Here in South Florida, almost every agency has, with the exception, I believe, of Hollywood Police Department and Davie Police Department down here. But you will see when you're reviewing the probable cause affidavit and the narrative, it'll say BWC warn. So BWC warn stands for body worn camera. And if you see that, you need to make sure you get that. So, we spend a lot of time at our firm really going through the discovery, and it's really, really critical to review any piece of digital evidence, those body worn cameras. In addition to the cameras that will be on scene, a lot of times you also get video of your client being transported. And even though they're long videos sometimes, it's very important to watch because you don't want to miss, something very important your client might have stated in the back of that police car. So it's important to make sure you have all the digital evidence, including the body-worn cameras. Florida Highway Patrol, they don't have body-worn cameras. However, they have dash cam or digital cameras, so you can see when they're having an encounter outside of their vehicle with your client, you could see that encounter, and they have audio too, so you can also hear that encounter. And we found a lot of times in our cases, we have had great results by finding the things in that digital evidence in the body-worn cameras. So, and a lot of times we'll get the discovery and we'll have, one officer's body camera, and then I realize, wait, there should be body camera this officer too. So we'll have to follow up and request it, and if not, file a motion to compel to get that. So body-worn cameras, especially in DUI cases, are critical and a really important part of reviewing and gathering your discovery. Now, the next thing on the list is medical reports, if any. So a lot of times the police officers in these cases will transport your client to a hospital prior to transporting them to jail. They claim that, a lot of times that this is for medical clearance prior to them taking to the jail. But it's very important to get those medical reports because if testing was done, there's observations that are notated a lot of times in medical reports. Certainly if, urine or blood was taken, which we're going to get to in a second, we need to know. And so we want those medical reports. A lot of times if it's a crash case, there will be, fire rescue that arrives on scene, and they will generate reports, the fire rescue will. So we want all those reports. We want the medical reports, fire rescue reports. So be cognizant of if you see that this was an accident in particular, but if you see your client was transported, you want those to request those additional reports if they weren't provided. Breath results, if any, along with agency inspection. So a lot of times in our discovery, we'll get the breath results. It'll be, a piece of paper stating the intoxilizer number and the breath results. There's so much more that you want to look into, and I could go on for a long time about breath results and breath tests. However, you want to make sure you have the breath results, and additionally, you want to make sure that FDLE has a great website where you can pull and look at those inspection reports, because a lot of times you could attack the breath if the intoxilizer has failed, there's been issues with it. So breath results, along with, I would add, the agency inspection report, which is done by the breath tech operator. And you want to follow up and also get, I would go on the FDLE website because there's great information on there. Urine, blood, I just mentioned, if any, this is really important too. A lot of times the state makes a mistake and they do not list the person who took your client's urine or blood as an expert. And in order for them to be able to testify about the results of the urine or blood, the state must list them as an expert. And they don't always know that. They mess up on that a lot. So it's important to take note of that. So these are just a list of things to look for when you're reviewing and you're gathering your discovery to build your defense and get to the next portion, which is the DUI motion. So DUI motion. do or do not. Okay, first one, traffic stops. Very, very important. So for traffic stops, right? So we were just talking about to look at the tickets, and that can provide information as to what your client was stopped for. But an officer, this has to have probable cause to believe a traffic violation occurred, okay? This is not reasonable suspicion. To stop your client, the officer has to have probable cause. So it's very important to look at what was the reason for the stop. And we're going to get into the different reasons that officers could stop your client. But it's really, really, this is not a subjective. So this is not a subjective by the officer. The validity of a traffic stop is judged on an objective basis. So the officer's knowledge, motivation, intention is wholly irrelevant. And we cited to the two cases, Hurd and Holland. So it's very important for traffic stops to first know that an officer needs probable cause, and that it's judged on an objective, not a subjective basis. So we call the first kind of cases you see a lot in DUIs. Oops. Hold on, I clicked something. Okay, sorry. The first kind of stop we see a lot in DUIs are called failure to maintain a single lane, right? So we refer to them a lot of times as weaving cases. But when people see someone failing to maintain a single lane or weaving within the lane, that could be a possible sign that someone may be under the influence. So, but don't be discouraged by seeing a weaving or your client failing to maintain a single lane. That is, oh no, that's a bad thing. It's not always. We've had great results in cases with the same situation. So we've listed cases here that say the critical factor, there needs to be more than just failing to maintain a single lane. So it has to be failing to maintain a single lane and impeding traffic. So, and that's what these cases say. Other cases hold in the critical factor for determining PC for maintaining a single lane is whether the vehicle is driving, erratically, irregularly, or endangering other vehicles. And it's a lot of, and our motions, we are in the 17th Judicial Circuit, so we use cases from our circuit to cite to. Certainly we use, Florida Supreme Court DCA cases as well, like Hurd, but it's really good to cite to the 17th or whatever circuit you are in. Other notable decisions about driving patterns. Here's some more really good cases. We have Crooks, which is a great case that says 2 or 3 occasions of moving slightly over a lane without creating a reasonable safety concern is inadequate to justify a stop. Okay, and then the next case of Alford, courts have held a stop to be invalid when a vehicle moves and crosses the right lane by several inches to 1 foot, approximately 6 to 7 times in a weaving pattern. Again, this is another case that's saying you need to find out and you need to know, and these are questions that you need to be asking when you take your depositions, is whether the weaving, whether the failure to maintain a single lane was traffic affected, was traffic impeded by the weaving or failure to maintain a single lane. Okay, next, investigative stops. Oops, I did it again. Okay, so unlike traffic stops, which require, again, the key is probable cause and objective standards. Unlike traffic stops, Investigative stops are a little bit different. So they only require reasonable suspicion. So this says police can stop and briefly detain a person for an investigative purposes if the officer has a reasonable suspicion supported by articulable facts that criminal activity may be afoot, even if the officer lacks probable cause. So a lot of times you have cases in DUIs where we've had a lot where our client may be sleeping, fell asleep behind the wheel. Now, sleeping behind the wheel doesn't necessarily mean DUI, but officers use that as a reason to say they're going to do an investigative stop to check to make sure that someone's okay when they're sleeping behind the wheel, that they're not suffering from some sort of medical emergency. So you have to, in all of these cases, a really important thing is to look at the totality of the circumstances. So that's why you got to really, when you're reading and going through the discovery in your cases, really look at those details, and the totality of the circumstances is also comes into play throughout these cases. So again, investigative stops do not need probable cause. They need reasonable suspicion supported by the articulable facts that criminal activity may be afoot. So when an officer is doing an investigative stop, and this is the Florida statute we cited, 901.151. So it's saying that, again, that an officer the key is temporarily detain such person for the purpose of ascertaining the identity of the person. They could temporarily detain to do an investigative stop, okay? And we've cited the statute that they could temporarily detain in the circumstances surrounding his presence abroad, which led the officer to believe that he had committed, was committed, or about to commit a criminal offense. This is a great case, the Montez Balton case, and this deals with the fellow officer rule. So, and in that case, it deals with a blood draw, and the officer, and I really encourage, if you need the site, we can provide it, but I really encourage you to read that case, because in that case, the officer that was taking the blood draw did not have knowledge of the facts and circumstances, essentially why they were doing the blood draw. So, and they found that the fellow officer rule did not apply in that case. So I threw that in there. I thought that was important, and it's a great case that we use in a lot of our cases. So that's why I added that in there. But back to the investigative stops, reasonable suspicion, like probable cause, is dependent on both the content of information possessed by the police and its degree of reliability. And this is what I was just talking about. Both factors, quantity and quality, are considered in the totality of the circumstances. So when we say totality of circumstances, again, the whole picture. And we have it's very important to distinguish, especially when you get a call. There's a 911 call stating certain information which ultimately leads to, let's say, a traffic stop. So it's very important to distinguish if the caller was an anonymous tipster versus, it says confidential informant, but really what that means is a citizen informant. So an anonymous tipster is someone who is just what it sounds like, just anonymous. Whereas a confidential informant or a citizen informant is someone who actually leaves their information, leaves their name and phone number. We can identify that person. And in Hall v. State, this is a Florida 4th DCA case. In that case, they held that where a citizen informant, okay, someone who left their information, a retail store manager alerted police that appellant and other man were acting suspiciously, but where officer did not observe appellant to do anything suspicious, there was no basis for an investigatory stop. So again, this deals with that the officer did not, although this was a citizen informant, the officer did not firsthand observe the defendant to do anything suspicious. So they were not allowed to base their stop what the citizen informant told them because they did not witness it themselves. So the court held it's a very good case that there was no basis for an investigatory stop. This next case, the Ellis case, it says a 911 call could be considered by on-duty officer in making an investigatory stop when the caller is a CI, but stopping officer, again, this is the same thing. The stopping officer must make his own observation. Okay, so I recently had a case where it was kind of a debate whether the person was an anonymous tipster or a confidential informant, but nonetheless, police are called out. Someone potentially causing a disturbance gets in their car, and the police stop the vehicle, and they say that's an investigative stop. Our argument is, they did not observe that vehicle commit any, traffic violations and didn't observe our client do anything suspicious in their presence. So the argument was there was no basis for an investigatory stop. So we talk about here the Department of Highway and Safety motor vehicle case, recognizing that a legitimate concern for the safety of the motoring public can warrant a brief investigatory stop, and this is what I was referring to a few minutes ago, to determine whether a driver is ill, tired, or driving under the influence in situations less suspicious than required for other types of criminal behavior. And so this is actually, I don't know why it's there 2 times, but that's what that case holds, that an officer can make a brief stop to, again, why is this person sleeping? Is it a medical emergency? Are they just tired? So that is the Department of Highway Safety and Motor Vehicles, and there's also another case cited below that deals with the same issue. Okay, accident report privilege. So a lot of these DUI cases are accident crash cases. And accident report privilege, which we're going to talk about now, is something that if you have a crash case, a case involving an accident, in every single one of those cases, you should be filing either a motion in limine or a motion to suppress any statements regarding the accident. So what does that mean? And we're going to get to it now in detail. So even if you're successful in suppressing or keeping the statements out, that doesn't mean that the body-worn camera of your client cannot be played. So it could be played, but it needs to be muted so the statements don't come in. But the officers, keep in mind, can still, that body-worn camera, the video could still be played, and the officers could still testify as to their observations, that your client was staggering when they walked, that your client was speech was slurred, but it keeps those statements that were made regarding the accident out. So, and this is straight from the Florida statute 316.066, which says, that Florida law places a legal duty and an obligation on an individual in an automobile accident to provide information to law enforcement for the purpose of completing an accident report investigation. So in Florida, they want this statute and this law, they want people to speak open and honestly about the accident, but they don't want people to incriminate themselves. So that's why they came out with this accident report privilege, and that's what the next thing says. In exchange for providing this potentially incriminating information, the legislator granted immunity to such statements so that it may not be used in any criminal or civil proceeding against the defendant. So if your client, as a part of the crash investigation, says, it was my fault, I just had some drinks at the bar, you should file, again, any of those statements, you should always file a motion under accident report privilege, under this statute, and we're going to get into the cases like Marshall, which are great to keep those statements out. And, you know, we've had, even though we file motions and to suppress and we list most of the time in our accident crash cases, accident report privilege is one of the first issues we raise. You know, we've been very successful sometimes on the accident report privilege, but not the other issues. But even just winning that, you may not think it's a huge issue. We've had great results, such as getting a reckless driving on a DUI case because of getting these statements out. So motions are, and I should have mentioned this before, filing motions in DUI cases, and in almost every DUI case that we have, we can come up with a legal basis to file a motion. And when we do file the motions, this is how we get our great results. A state attorney is not going to just take a DUI and look at it and say, okay, we're going to give you a reckless driving. That's very, very rare. A way to get a reckless driving is to file these motions. Okay, so back to accident report privilege. So this says, so to the purpose of, again, an accident report privilege is for people to be open and honest and not feel like what they say about the accident will later turn and be used against them in a criminal or civil case. So accordingly, when an individual in an automobile is suspected of DUI, law enforcement must advise the defendant the investigation is now a criminal investigation. Okay, so crash investigation's done. Most of the time you have a crash, an officer or doing the crash investigation, or a public safety aid person doing the crash investigation. And then another officer comes. Sometimes it's someone on the DUI task force, if the agency has a DUI task force, comes to do the criminal or DUI investigation. We always argue that defendant's Miranda warnings must be read before any statement may be admitted. And we cite to State v. Evans, State v. Marshall, State v. Nordstrom. Now, there is a new case, which if you feel free to email me, I'll give you all my information at the end, but there is a new case that recently came out this year, so 2023, last month in January, State of Florida v. Bender. And it was a case out of our circuit, and, you know, it's not the greatest for this, but I would continue to always argue. I would review that case, but always argue to the judge that once a criminal investigation begins, Miranda warnings should be read, because a lot of times they are not. And actually, the case I was talking about, the new case Bender, cites to a case we use a lot, which is Bender, and which Bender summarizes the cases of Nordstrom and Marshall. And it says, we emphasize that the privilege granted under the Florida statute applicable if no Miranda warnings are given. Further, if a law enforcement officer gives any indication to a defendant that they must respond to questions concerning the investigation of an accident, there must be an express statement by law enforcement officials to the defendant that this is what they're supposed to say. You know, the accident portion is now over. This is now a criminal investigation, followed by the Miranda warning, in order for any statement to be admitted. Now, this is what I was saying before I got ahead of myself. So if you win, meaning if the statements are suppressed, kept out, again, this only mutes the audio portion, okay? The jury will still see video and hear the officer testifying about their observations. Be prepared for the judge to fight you on whether Miranda must be read. And again, we argue that it should be read. The judge will probably fight you on that. And this new case of Bender is going to even cause it more difficult. But again, fight that when the hats are changed. So meaning, I forgot to mention that I said that a lot of times, you know, it's a crash investigation officer, and then another officer takes over. a lot of times, sometimes it's the same officer who does the crash investigation and the DUI investigation, and they say they're changing hats. So when the hats are changed, they need to inform your client that the accident is over, the DUI investigation has begun, and read Miranda. So that was accident report privilege. And again, I'm just trying to provide a summary. There's so much more to each one of these subcategories we're talking about. If you're not, obviously as mentioned, we're in the 17th Judicial Circuit. Look for cases that are in your district as well. But next issue is field sobriety exercises. They're not, although I was in trial recently, maybe 6 months ago, and the state attorney in the trial called them, okay, and that's why we always flipped that said they're field sobriety test, or tried to call them that. One of the things we always put in our motion in limine is they are not able to call them field sobriety tests. They are not tests, they are exercises. Okay. So what does an officer need to request a person to perform field sobriety exercises? They need reasonable suspicion that the driver operating the vehicle may be under the influence. Okay, and this detention cannot occur. And again, this is an objective, not subjective manifestation that the driver is under the influence. Okay, so they need reasonable suspicion, and then we have the objective standard. All right. Field sobriety exercises. There was a case in the 17th Judicial Circuit, and if you need it, feel free to email. It's the Marcellus case. And what it said, it wasn't a great case for us, but what it says is that to command someone to do field sobriety exercises, you need only reasonable suspicion, okay? That you can't argue command requires probable cause. So you could still argue Probable, and that is that involuntary consent, because a client, we love the Probable case, because a client is acquiescent to police authority. And that's a way to get around this police only need reasonable suspicion to command your client to perform these field sobriety exercises. So in State v. Luim, okay, this is another 17th Judicial Circuit case. The court, this is a great case, the court determined that the officer did not have reasonable suspicion necessary to detain defendant for a DUI investigation and request that he perform field sobriety exercises, where officer did not observe impairment in the defendant's driving or appearance apart from an odor detected on his person and inside his vehicle. So remember, odor is not enough, right? It's not, I could have 2 glasses of wine, get in my car and drive and have the odor of alcohol. That is not the determining factor if someone is driving under the influence, because it has to be their normal faculties have to be impaired. So while the odor of alcohol is certainly a factor to be considered in determining reasonable suspicion, the mere odor of alcohol beverage on someone's breath is not inconsistent with, again, someone being able to operate a motor vehicle, that their normal faculties are not impaired. And another great case. So Bertoni, I've won several motions based on this case. So in Bertoni, the officer asked to perform roadsides, and the signs of impairment that the officer observed was odor of alcohol, red eyes, flushed face, and a combative attitude, okay? So, but there was no observations of a driving pattern. So, speeding, is not always indicative of impairment, and it's not a sign of impairment. so there was no weaving, there was no traffic violations in Bertoni. The reasonable suspicion that the officer in Bertoni used was odor, red eyes, flushed face, and the defendant had an attitude. The court held that that was not enough to have, that was not enough reasonable suspicion to ask the defendant to perform these field sobriety exercises. Okay, so back to, so voluntary versus involuntary consent, okay? And this is very important when you're watching the body cameras to listen to the words and the language the officer is using towards your client, okay? And again, here we go. Whether consent is voluntary is a question of fact to be considered in the, here we go again, totality of the circumstances. This is Tyson v. State out of the 5th DCA. A case that we use a lot, that we've been successful in arguing, that our client was just acquiescent to police authority, thus the field sobriety exercises were not voluntary, is this case State v. Lynn. In State v. Lynn, the court held where the language used by an officer in instructing a defendant to perform field sobriety exercises is consistent with the finding that the defendant was acquiescing to authority, then the defendant's performance of field sobriety exercises was not voluntary and evidence should be suppressed. So again, to get around the, you only need reasonable suspicion to command, the Marcellus case, we have a case recently that our firm won, my partner, Maddie Ross, and she argued, she was successful in arguing that her client did not voluntarily perform the field sobriety exercises because her client was just acquiescent to a show of authority. I have a great motion that I recently filed that I'm really excited to argue. That's coming up and it's dealing with the same issue, and the language by the officer in this case, you know, my client's saying, I'm so nervous, I don't know, do I have to perform these exercises? And the officer is using language like you need to, you have to. So hoping to be successful based on the language that the officer used and taking into account the entire totality of the circumstances. Probable cause. Like I mentioned that in every case, accident report privilege should be raised. Also in motions, it's very important to argue probable cause, okay? Because let's say we are successful in getting the field sobriety exercises suppressed, okay? That doesn't necessarily mean the case is good, the entire case is going away. But that can lead to the argument that the police did not have probable cause to arrest your client. So speaking of, I wanted to mention there is a case, Howitt, H-O-W-I-T-T. And again, if you need any of these citations, feel free to email me. It's a great case where the client refused to perform these field sobriety exercises. And in that case, the court found that if the officer did not tell the defendant that their failure to perform these field sobriety exercises could be used against them, then the state could not argue the consciousness of guilt argument. So I just wanted to, before I forgot, I wanted to mention that it's a new case, it's a great case, and I have that coming up to argue, added it to my motion. So here we are, back to probable cause. Okay. No PC for DUI arrest. So you can't arrest based on a refusal. That's what made me think of that case. So the exercises are voluntary, and refusal to participate in the exercises is not what subjects the driver to arrest. So probable cause is a great argument, again, to taking into account, again, the totality of the circumstances for everything, that the officer did not have enough to even, not enough probable cause. Remember, the probable cause is obviously much higher than reasonable suspicion to effectuate the arrest of your client. So don't forget, don't think just because, oh, great, I have this wonderful, argument to suppress the field sobriety exercises, I don't need to put in the probable cause argument. Definitely put in the probable cause argument into your motion. Now, before we conclude, I wanted to talk about a couple more things, but I wanted to speak about plea or trial meetings that are very important prior to a motion hearing, that we do not just prior to trial. So when you meet with your client, obviously Manny's going to talk about how the initial information, how important that initial information is to gather, right? You want to know, do they have any medical issues which could affect their performance on these field sobriety exercises? Different to know your client, right? That's the goal. But you also want to have a really, really subsequent sit-down meeting with them before this motion, right? So after you take your depositions, but prior to doing the motion, you want to go through their case in entirety with them, right? And go through all of the issues that you plan on raising at the motion hearing. And really important, you want to make sure you go through the discovery with them, okay? You want to show them those body-worn cameras. You want to go over the digital evidence with them, because you don't want to be in court at your motion hearing for the first time and them seeing those body-worn cameras, right? So that's something that's really important. We highly recommend having a plea or trial meeting. I also wanted to mention, we've had really great success in, speaking of the body cameras. So they've really been helpful. And we've used the case, there's a case called Wiggins. And in the Wiggins case, the court found that even if, like, we have an officer come take the stand and they testify that one of the signs of impairment is that your client was slurring, right? They love to put slurred speech as a sign of impairment. You watch the body camera and you see your client is speaking just fine. One of the things you want to know, obviously, is English is your client's first language. Do they speak with an accent? But you review the body cam and there is no slurred speech. So that's another great thing that the Wiggins case holds, that by having in today's world, that by having these body cameras, if the body camera, right, contradicts what the officer is testifying to, the court can disregard in its entirety the officer's testimony and base their observation on the body camera and find that your client didn't in fact have slurred speech, right? So a lot of, in these DUI cases, we've covered odor of alcohol, and again, odor of alcohol is not enough. Bloodshot, watery eyes, many reasons people can have bloodshot, watery eyes, flushed face, right? Slurred speech, those are the classic things that you see in your DUI cases. Just because you see those, don't be discouraged. Just because you read the probable cause affidavit and are like, oh, this sounds really bad. We promise, when you actually go through and break down your client's case, gather the information at the initial interview, take the deposition, get this helpful information, review, obviously before taking the depositions, as we talked about earlier, gather the information, review the discovery, attack the issues, no reasonable suspicion to even begin a DUI investigation. Even before that, did they have a reason to stop your client? Were these field sobriety exercises voluntary, right? And then, there's so much more to go into. Then if your client provided breath, were the policies and procedures followed regarding breath? Was the 20-minute observation period done correctly. Speaking of, one more thing I forgot to mention as far as videos. So a lot, I think mainly Broward Sheriff's Office down here, but they do have videos at the breath tech places. So right, in breath cases, it's important to know, obviously, was the intoxilizer, was the breath a handheld, or were they taken down to normally the Broward Sheriff's Office station to provide a breath sample? And if they were taken there, you will get a video. I don't know why they don't provide a video of when your client's giving the breath sample, because that would be very helpful. But you get a lot of times, we get a video of them reading them implied consent and them asking them those questions, preliminary questions, when they're at the station prior to giving their breath sample. So that's another video I forgot to mention when we were talking about body-worn cameras and digital evidence. That's something that to look for when you're gathering your discovery, if that exists. So to wrap up, these cases, DUIs, don't be afraid. When I first started doing them, they're great cases to file those motions. The case law, go through, gather your discovery, file the motions, and we are confident that as we do, you will have great results. So this is about me. You could scan below to find my contact information. My email is Susan, my first name, at rossenlawfirm.com. Be happy to answer any questions, share any motions, and any cases that I mentioned that weren't in the slides, but the slides should be available to you, so you didn't have to. I should have told you you don't need to write down any of the cases. But thank you very much. It was a pleasure, and keep in touch.